Yes, Mr. Ramlal.
Good morning, my lords. I appear for the appellant with Mr. Ben Jones, and for the respondent, my learned friends Zelika Haynes Suhon and Carrie Ann Oliveri of the Trinidad and Tobago Bar appear via video link.
Can we just check that the system is working?
Yes, please, my lord.
That they can hear you and that we can hear them. Ms. Haynes Suhon. I'm not sure it is.
Good morning, my lords. Good morning, Mr. Ramlal.
Yeah, thank you. And you can hear us all right, can you?
I am hearing you, my lord.
What was that? Yeah.
I think it's if they mute their mic on that end, it helps the feedback, I think.
I think it's still got feedback. But I don't know which end is causing the problem. Can you alert those upstairs to see if it can be cured while we continue? Well, do put your hand up if there's a feedback problem at your end or you can't hear us. But Mr. Ramlal, would you like to continue?
Much obliged, my lord. I'm sorry to have to trouble the board with an appeal that deals with the issue of costs. But it is the first appeal to reach the board since we've adopted the different rules. Since we adopted a new set of rules. There was one previous appeal which I'd come to, but it didn't concern the issue of the quantification of costs. Perhaps I should start by posting some milestone events in the chronology. On the 31st of May 2006, the claim was dismissed, and after the trial judge ordered that the costs were to be quantified or assessed by the registrar.
We don't have a transcript of the hearing, but presumably that was the matter subject of oral argument, or if there was any dispute about it, when the judge gave her oral judgment.
No, we do have a transcript, but the answer is no. There was no argument on costs, my lord.
So what happened? The judge gave the judgment and that was it?
That's it.
Or it went away?
That's it, yes. The judge gave her judgment at the end of the trial, and in giving her judgment on liability, she gave a one-line decision on costs as part of her judgment. As
part of the judgment that she delivered orally?
That's correct, and which was subsequently reduced into writing. Was it not? Yes. So there's
nothing about costs in the written judgment?
Correct, my lord. Correct.
But there was in the oral judgment, you're saying?
No. In neither the oral nor the subsequent written judgment is the issue of costs addressed in terms of the reasons for making the order.
So she made the order we see drawn up orally?
Yes.
But nobody then said anything about it? Nobody raised any objection or said, I want to make submissions or...
No, because my lord, my lord, once the judge pronounces the order, that's it. If she wishes to give the parties an opportunity to be heard on a matter, she will extend an invitation. But
well, normally, if you feel that the judge just made an order without hearing argument, and you want to object to it, you would jump up and say. Excuse me, but I haven't had. May I be heard before?
Well, yes, I accept. I can't argue with that. I accept that. I came into the level of the appeal, but yes, certainly we'd be open to counsel to say, look, my lady may be heard.
Yes, you've said that the cost must be paid, but I would like to submit that if that's not what you said, they should be on the prescribed basis.
Well, I accept that, my lord. Yes. Can I come to that, my lord, and whilst I think about it, because I obviously see the point in that, my lord. On the 7th of July 2016, a notice of appeal was filed, and new attorneys came on record, and the notice of appeal gave express notice that we were challenging, that the appellants intended to challenge both the order for dismissal and the order for costs.
Well, how did it do that beyond simply listing the whole of the order? Which the rules require you to do anyway, don't they?
Well, not necessarily. The rules do provide for you to appeal against a part of an order.
Yes.
So that,
but nothing in the fact that the whole of the order was identified would have alerted anyone that there was a submission being made about costs, quite apart from the main submission that the judge had got the answer to the case wrong.
But that's true.
In fact, it was clear that there was no independent appeal against costs because the only ground was that there wasn't sufficient evidence for the judge's conclusion, something like that. And if that had succeeded, well, obviously the costs order would have been overturned as well. But that ground had nothing to do with costs if the judge's conclusion was correct.
Lord, I accept that. All I can say, Lord, is that the notice of appeal, insofar as the rules do provide that you can appeal against a part of the judge's order, and insofar as the appellant gave notice that she was challenging both the order made on liability and the order on costs, notice was given that both those aspects were challenged. Now, my lords, I accept, of course, that the grounds did not specifically deal with the issue of costs, and I'll come to that in a bit, my lord. Now, my lord, the practice is this: where a judge delivers an oral ruling, and you seek alternative legal advice, as the case may be, and you have a deadline to file a notice of appeal, oftentimes what happens is that you would put in what is called a bare notice of appeal in the form that we've done here, and thereafter, when the judge provides the written reasons, or you obtain the transcript of the actual hearing, if there was cross-examination, once you've obtained that, then you would perhaps refine the notice of appeal or put in submissions to indicate what your position is. And that's precisely what happened here. The object really is really to give notice to the other side and to the court as to what the position is. In the notice of appeal, if you wish to appeal one aspect of the judge's order, you will say so, and you will then say what aspect of the order is not subject of appeal. But I'll come to that in terms of what the judge's positive duty, regardless of whether an appeal is filed or not, is to litigants in the judicial system. Because my submission would be that a litigant is entitled to a properly reasoned judgment by the court. And that
before you can get to that submission, you have to show that you were entitled to challenge the costs order at all.
Sorry, beg your pardon?
Before you can get to arguing about what was wrong with the costs order, you have to show that you had a basis for challenging the costs order at all, when there was no ground of appeal that challenged it, and on the face of it, and you didn't have permission to bring an appeal against costs anyway.
Well, my Lord, I accept that. I can't argue with that. But what I do say is this, my Lord. When I take you through the cases, you will see that if there is an order that is obviously wrong, the court has a duty not to turn a blind eye to it, but to treat with that order, and the courts have often in fact done so. And in this case, there is no dispute that the order that was made was wrong in law. And insofar as that is the case, I'll show you.
That's because it used the word quantified, as I understand it.
Well, my Lord, yes, it's because it uses the word quantified as opposed to dealing with costs on the prescribed basis, which is really what should have happened in this case. And even the court...
Well, if you wanted to... I mean, your bare notice of appeal, I've just turned it up on page 467, said that details of any finding of fact or law that was challenged would be added upon receipt of the learned judge's reasons.
Yes.
And when you got the learned judge's reasons, I think several years passed without anything being added.
Well,
in fact, nothing was ever added.
Well, I accept that, my Lord. The problem is, my Lord, when the written judgment came, it didn't provide any reasons.
Well, that was the time to add in your grounds of appeal if you wanted to. I now am challenging the judge's order on costs because it wasn't reasoned.
Well, my Lord,
that was never done.
My Lord,
you can't come along to the Privy Council years after the event and start complaining about something that you never did when it was said in the bare notice of appeal that it would be done. It has never been done.
My Lord, I accept that. What transpired was this, my Lord. I believe both parties had written to the court to inquire whether or not we could have the transcript to see whether or not the reasons for the decision was contained in the transcript. And we certainly had written the court to specifically ask for the reasons for the cost order. So, my Lord, we were awaiting that. That, in fact, actually came after the hearing and decision of the Court of Appeal. And I'll come to that to show you. So we were, both parties, to be fair, were waiting on that, and I will show you in the transcript at the hearing where that is in fact recorded, my lord. So that when we got the judgment, it didn't actually deal with the issue of costs, and the approach taken by the parties was to write the judge to say, well, look, we'd like to have the reasons on the order for costs, and also the transcript of the oral hearing was outstanding, and we thought it might have been contained in that.
Well, you'll come to it, but at the moment, the point seems to have first been raised in the submissions that you made to the Court of Appeal, starting at page 470.
I beg your pardon, 470, my lord?
Yes. Am I not right in thinking this is the first time you actually raised the issue of...
If that's... My lord,
that you raised the issue of costs as a separate... matter before the Court of Appeal in paragraph 4?
I would say qualified yes, and the qualification is that in the notice of appeal we did give a notice that we were appealing against the order for costs. We did not put the ground because we are awaiting the reasons from the judge, and the practice is that until such time as you get the reasons, you'd put in a bare notice of appeal and you'll amend when you get the reasons. Those reasons came, to the extent that we were waiting and hoping to get them, they came after the appeal had been finished. And that's
but does the bundle show that there was a letter to the judge asking for reasons or anything like that?
Well, can I take you through? It's recorded during the course of the hearing, and I'll take you to it now. Yeah.
You're talking about the Court of Appeal hearing?
Yes. It's at page 35. Yes, at page 35, this is the transcript of the hearing in the Court of Appeal, and at line 5, you will see Justice of Appeal Barrow. Now, if it were that leave had been granted on the issue of costs, we would more than likely would have had it. My lord, Mr. Pariagson, who was counsel in the Court of Appeal, said, my lord, in speaking with my friend, my learned friend on the other side yesterday, I believe that Ms. Suhan was attempting to get a transcript of when the oral judgment was delivered to see if the judge made any remarks about or gave any reasons as to costs. But I don't believe...
Hold on a minute. It wasn't for her to get that transcript. Your side wanted to appeal. You had on the face of it heard the judge use the word quantified, and surely it was... My question is there anything in the bundle which shows your side asking the judge for reasons?
There's nothing in the bundle, but there's nothing in the bundle, but I'm advised that we did write, but more than that, I will take you to the actual rules to show you how the practical administration of these matters work. Once you file a notice of appeal, the rules provide that the Court of Appeal itself sends the notice of appeal to the trial judge for reasons to be prepared, and that's the way it works. Now, we do write as the case may be, but quite frankly, once the notice is issued by the Court of Appeal, that's really the prompt for providing these things. Now, the application...
Did your side ever ask for the transcript of the hearing?
My lord, we certainly did, my lord. It's not in the bundle, but yes, I'm advised that we did, yes. Yes, we did. We certainly did. But to the extent that either party asked for it, the point is we did not have it.
Well, you didn't say the appeal can't take place because we don't have the transcript, so there wasn't a transcript, and there you are.
I'm not, no, because if the transcript is not in fact available or reasons are not available, it's not that the appeal court can deal with the matter, and they will have to deal with it.
Well, what was wrong with the way they did deal with the matter?
Well, I'll come to that. What we say was wrong is that they recognized that the order for costs was wrong, but they said that they could not deal with it because no leave had been granted. And under the rules, they could have entertained the appeal and granted leave themselves to reverse what they themselves admitted was a wrong order for costs.
Were they asked to?
Of course, no. That's the whole point of the submissions that we filed, and that was the whole point of the hearing. We were
asked them to grant permission for a costs appeal.
And to reverse the order, yes.
I thought the argument was you didn't need permission to pursue the costs appeal.
Well, that was one of the arguments, but if we, in the event that we needed appeal, we were asking for it, but more importantly, we were saying...
Well, I'd like to see that at some point.
Certainly, my Lord, certainly. Certainly. So, my Lord, can I then, therefore, skip through some of the preliminaries, because I get the sense that the board is on top of the preliminaries.
Who attended the oral hearing before the judge on your side?
My Lord, there was different counsel in the matter at the
yes,
time.
but so counsel attended.
Yeah.
Hear my question now. So counsel attended. Anybody else?
My Lord, yes, counsel attended, yes.
Anybody else?
Oh, I'm sorry, my Lord, 1 second. There was an instructing attorney seeing on the judgment, Ms. Persad, attended as counsel, instructed by Ms. Kadir and the transcript. When the judgment was given, it was just Ms. Persad who was counsel. There was no instructing.
So your counsel instructed at the time would have known, now you say we've got the transcript, that there was no argument about costs.
She would have known because she would have been there,
or
yes.
asked to be made.
She would have known because she was there, yes. No.
Yes.
Yes, certainly. I concede that. I concede that. So, my lords, can I then, my lord, take you to now, my lord? It's not what is not an issue is whether the appellants should pay costs. What is an issue is the quantification, the method, and the basis for quantifying those costs. That is what is an issue.
Well, it's only an issue if you get to the point where you're entitled to, you show that costs was, you had a costs appeal properly before the Court of Appeal.
Well, I accept that, my lord. I accept
That's
that.
the first question.
Yeah, sure, I accept that, my lord. And of course, if the order was wrong in the High Court, the error is compounded because of the Court of Appeal's order that they pay 2/3 of the assessed costs in the High Court. So that if the High Court order is wrong in terms of the quantification of the costs, then it means also the order made by the Court of Appeal would also be wrong. It's a double whammy. So that's the importance of the appeal from the standpoint of the appellants. Now, my lord.
Can I just ask you, when you say it's not an issue that your side must pay the costs, is it an issue as to whether those costs will be indemnity costs?
Well, my lord, I saw that being raised for the first time in the case for the respondent. But I don't believe that issue has never arisen before. The judge didn't make, I didn't understand the judge's order to be costs to be quantified on an indemnity basis.
That's what you'd expect in this sort of case, isn't it?
It would, and it may be again, but again, equally, as my Lord Legard points out, that would have been a matter for counsel for the respondent to raise at the material time and say, well, I wish to be heard on the appropriate order because I believe you're making the wrong order. But to the extent that that point is being made against me, I say it seems as though the parties are ad idem before the board that the order for costs is wrong.
Well, I've looked at the practice guide to the assessment of costs, which is in the bundle, which clearly show that standard basis and indemnity basis are alternatives available to the court.
Yes.
Where the judge doesn't specify the basis, is there any reason why the cost judge can't decide on the appropriate basis?
There is, my lord.
Because the rules appear to give quite a wide discretion to the cost judge once a costs order comes for assessment.
Well, look, the registrar who deals with taxation, their jurisdiction is extremely circumscribed. Their taxation is pursuant to the order of the court, and the practice generally is if the court wishes to make an order that the costs are to be on an indemnity basis, that is a serious order. The court will have to so specify and give reasons for it. That is how it's done, because there are two completely different bases for taxation of costs, and there are two completely different types of orders. So, my lord, to the extent that it is said that the correct order may have been or should have been costs on an indemnity basis, that is certainly not what the judge ordered at all. And that's why I make the point, if that argument, to the extent that that argument is being raised, it means that the parties before the board are ad idem that the wrong cost order was made. It only reinforces our presence here today. But it is not, my lord, as you suggested with respect, that the taxation assistant registrar has a discretion when taxing a bill to utilize either indemnity costs or the assessed costs without reference to the actual order made by the judge. They are two completely different concepts, and that's why the judge himself would have to so specify in the order.
Certainly, your submission, as I understand it, is that the registrar can't assess costs on an indemnity basis unless the judge has specifically ordered it.
Correct.
And has used the word indemnity, is that right?
Correct. They must say costs on an indemnity basis.
And is there anything in the rules or the practice directions to that effect? Or is it simply a practice inherited from, for example, England and Wales?
Well, it certainly is the practice in the jurisdiction. I can't say that I've seen anything specific in the rules on it, but I can check on that.
The rules on cost don't appear to refer to basis at all. They refer to assessment, but not to the indemnity or the standard basis that I've seen. I may have not seen them all, but I'm just telling you where I've got to so far in my
Of course, Lord, that's very helpful. Thank you.
Whereas the practice direction headed Practice Guide to the Assessment of Costs, issued, I think, by the Chief Justice, and I think in 2016, but I'm trying to remember where I got that from, does refer to there being two different bases.
This is 659.
But yes, 659, 660 in the bundle. But it doesn't, I think, indicate how the court, using that sense compendiously as including the trial judge and the cost judge, if they're different people, determine what the basis should be.
Well, Lord, insofar as this deals with it's a guide to the assessment of costs, it presupposes that an order authorizing the assessment of costs on a particular basis has been made. So it's a guide to assessing the costs pursuant to an order that has already been made. That is how I would interpret it, my lord, but it does not obviate the necessity for the judge to actually make the order which would give rise to the authorization for the basis upon which the costs could be taxed. It would be, my lord, a very radical thing for us in Trinidad to say that the power to decide on which basis the taxing master, who is an assistant registrar, can tax those costs would be in the discretion of the taxing officer, my lord. Certainly, but my lord, even so, if a judge has to make costs on an indemnity basis, my lord, that's a huge departure from the general rule, and that is what reasons would have to be given, full reasons would have to be given by the judge as to why they're making such a departure. Now, my lord, insofar as the rules may be silent on it, what I do say is this. What the rules are not silent on is the four methods for quantifying costs that are awarded. And those are fixed costs, prescribed costs, applying to the court to set a higher value for the prescribed costs by setting a higher value for the claim, or an application for budgeted costs. Those are the four options you've got as a litigant. And if you know that your opponent is alleging a matter that you think should result in a cost order outside of the prescribed regime, which you know is the general rule, then the obligation is on you, i.e. the respondent, to early on make an application to the court, and you will put in your grounds of the application, well, look, I'm applying for a cost budget, or I'm applying for the court to fix the value of this claim at a higher level than would otherwise obtain in accordance with the prescribed cost regime, and the reasons are as follows. A, they're alleging fraud. B, whatever the reasons, it's a complex matter, it involves several witnesses, whatever the case is, but that application has to be made. And that is the job of the litigants, my lord, not the court, as it were.
How do indemnity costs fit in with that?
Sorry, beg your pardon?
How do indemnity costs fit with that categorisation that you've just given us? Well, if you've got indemnity costs, that's not. How does that impact with fixed and budgeted costs?
My Lord, I think indemnity costs would be something outside of that. That would be in the discretion of a judge.
It would be under the rules, assessed costs, because the indemnity basis is short slang for basis of assessment.
Yes, I agree, but my Lord, to the extent that it is an alternative basis for assessing the costs, it is one that would have to be the subject of a judicial order made by the trial judge. That's as far as I can take it, because I accept the point. That would be an additional method for taxing the costs, my Lord.
So in a sense, the standard base, the categorisation you've just given us assumes that it's costs on the standard basis, does it, rather than the indemnity basis?
Well, not standard, because you see, each cost regime has a different approach to it, my Lord. And can I deal with that when I come to the leading case on authority, because the Court of Appeal has recently reviewed the whole question, and it might be of some assistance. But can I...
we only get to all this if you ever appealed against the costs order and had a right to do so under the statute. So that seems to me the point we deal first.
Well, can I then...
Respondents aren't asking us to change the judge's costs order. You're asking us to do so, but before you can get to that, you have to show you ever had a ground of appeal against costs.
I accept that, my Lord.
As far as I can see, you never did.
Well, my Lord, I hear you now. Can I then, in that regard, my Lord, can we go to the Supreme Court of Judicature Act?
What page?
Yes, my Lord, I'm just bringing it up now, please, thanks. It starts at page 630. And it says at section 38, civil appeals from the High Court, and it says the court shall have jurisdiction to hear and determine appeals from any judgment or order, and it says the Court of Appeal shall have all the power, authority, and jurisdiction of the High Court, and subsection 2 is the relevant one. And it says that no appeal shall lie except by leave of the judge making the order of the Court of Appeal from an order made with consent, an order as to costs, a final order of a judge made in a summary proceeding. Can I pause there? 2A, B, and C, no appeal shall lie except without leave. I'll come to the cases to show, my lords, where in cases where no leave was obtained, the court nevertheless, despite that the wording of subsection 2, entertained the appeal and granted relief where the order was plainly wrong. And that, my Lord, is my answer to the point that which I can see that there is no actual ground in the notice of appeal.
And you don't contend that you assert that you ever asked for leave of the judge or the Court of Appeal?
My Lord, I'll do the best I can with the transcript, and the submission would be that we, as a first port of call, we said no leave was required, but in the alternative, that the court can and should deal with the matter by reference to the provisions, and I'll come to that, my Lord. And implicit in that, we say, would be yes, that we were asking for leave. Can I then take you, my Lord, to section 39 on page 631? At 39.1, it's the usual orders, the usual power of the court to vary any order made and give any, and then we come to subsection 2. The powers of the Court of Appeal under this section may be exercised notwithstanding that no notice of appeal or respondent's notice has been given in respect of any particular part of the decision of the High Court by any particular party to the proceedings in the court, or that any ground for allowing the appeal or for affirming or varying the decision of that court is not specified in such a notice.
So that's a discretionary power.
It is, my Lord, I accept that. And I'll come to how that discretion is to be exercised judicially and what the established case law says about it. Because what it suggests, my Lord, is that if the order is plainly wrong, that is when the discretion should be exercised, undoubtedly.
Broadly speaking, your submission is that the Court of Appeal has a discretion to consider a ground of appeal, even though it's not in the notice of appeal, either in its original or amended form.
Correct. And further, that discretion is exercised when the order is plainly wrong. And further, may make such order on such terms that the court thinks just, to ensure the determination of the merits of the question, the real question and controversy between the parties. The powers of the Court of Appeal in respect of an appeal shall not be restricted by any interlocutory order against which there has been no appeal, and the Court of Appeal may make such order as may be just in the circumstances. Essentially, the Court of Appeal, my Lord, is in the position of the High Court judges. They can make any order to meet the justice of the case. Can I? Well, I should raise it to the outset. I sent a supplemental bundle,
yes.
And can I perhaps take you to that supplement? Can I take you next, my Lord, to page? To the issue of the quantification of costs, which is starts at page 635.
Sorry, of the supplementary bundle?
No, I'm still on the main bundle. I'll go to the supplementary after.
Yes.
And these are the costs rules, and they're very detailed, my Lord. I mean, when the Rules Committee agreed to these cost rules, it was a subject of a lot of discussion and consultation and so on. So the first option is fixed cost. You'll see it starts at 637. So the first option is fixed costs at 67.4. And the second option is prescribed costs, which is 67.5. And that's the general rule is that where 67.4, which is fixed cost, does not apply, and a party is entitled to costs, those costs must be determined in accordance with appendices B and C.
I'm sorry, where are you reading from?
I am on page 637.
Right.
67.5. Rule 67.5. Are you with me, Lord?
Yep.
So, so the general rule is that they're entitled to the cost, which must be determined in accordance with appendices B and C, and in determining the value of a claim to be decided, in the case of a claimant, the amount agreed or ordered to be paid. In the case of a defendant, the relevant one would be Rule 3, and that is if the claim is not for a monetary sum, it's to be treated as a claim for $50,000, which results in a prescribed cost being in the sum of $14,000. 67.6, applications to determine the value of a claim for the purpose of prescribed costs. And you can do so at a case management conference to determine the value to be placed in a case which has no monetary value. And then 67.7, prescribed costs.
Well, we never got to prescribed costs here because the judge exercised the discretion not to follow the general rule.
Well, my Lord, the judge, the judge made an order, but there is no explanation as to why.
I understand that point, that she didn't give reasons, but that was the order she made. You accept it?
Yes, I accept it. I must accept that that's the order she made, my Lord, yes.
But was it not, correct me if I'm wrong,
Sure.
Was it not common ground in the Court of Appeal that although the judge used the unusual word quantified in her order about costs, she must be taken to have meant assessed?
Yes, that's common.
That was common ground.
It is.
In other words, she wasn't using quantified as a way of dealing with prescribed costs.
Correct.
She was using it as a way of ordering that there be
I accept
assessed
it.
costs.
Yes, no, that is not in dispute.
And is it not also common ground that if a judge does that, that overrules the default provision in 67.51?
In other words, the judge didn't follow the general rule in this case. Chose not to.
Yes, I can accept that, my Lord. I can accept that.
So here we have a case in which we can effectively forget about fixed costs and prescribed costs in terms of working out what the effect of the judge's order was. we are in a territory of assessed costs, so far as she was concerned.
Well, save and accept, my lord, that presupposes the first issue is whether the learned judge was correct to make such an order and to take it outside of the prescribed cost regime, because, my lord...
But you're seeking to say that her order was plainly wrong, so as to get yourself within an ability to interest the Court of Appeal in circumstances where, let's suppose, there's no notice of appeal or grounds of appeal raising costs.
Yes, and I do so, my lord, because...
But are you saying that that's plainly wrong because she used the word quantified rather than assessed, or because it was plainly wrong in that case to order that costs be assessed?
I'm saying this, the latter, my lord.
The latter?
Yes.
So it's not just a quibble about the language she used?
No. What I'm saying is, my lord, given the way the rule is structured, the rules are structured as follows. Every litigant knows beforehand, because of the policy behind the rules, that there must be consistency and predictability about the cost exposure to litigants. The aim of the rules is to know that beforehand, so that litigants can make an informed decision about the conduct of litigation. That's the whole purpose of the shift in the new rules.
But some things you don't discover until the trial, and here the judge found at the end of the trial that your clients were shamelessly lying. And if this isn't the sort of case where you expect the judge to step outside the general rule and not award prescribed costs, but to order them to be assessed, it's hard to think what is.
Well, my lord, that might be so, but, my lord, a judge, if a judge has to step out of that crease, the judge, in my respectful view, is duty-bound to do two things. One, she must give the parties an opportunity to be heard, and it is not, in my respectful submission, an answer to that, which is an obligation that the judge has to say, well, it's equally open to counsel to get up and shout and say, well, I wish to be heard. The judge has a positive duty before they make such an order to step out of the general comfort zone of what the general rules and principles are, to invite counsel and give them an opportunity to be heard. That's the first point. The second point is that the judge, as part of the constitutional right to a fair hearing, has an obligation to give a reasoned judgment as to why you depart from that rule. Now, the shamelessly lying bit, it's there, yes, I can't get away from that, but in what context? The judge raises that in the context of whether she was addressing her mind to whether she should refer the matter to the DPP. And she did the correct thing, which was to invite submissions on that. But the limited issue that she invited and received submissions on was whether she should make a reference to the DPP.
Well, one might assume that in the case where the judge was considering referring it to the Director of Public Prosecutions, the counsel on your client's side who turned up at the hearing might have thought that they couldn't properly put forward an argument against costs being assessed, and that they were pretty lucky that the judge hadn't ordered it on the indemnity basis. So the best thing to do was just to keep quiet.
Well, my lord, I mean, that's one way to look at it, but I mean...
Well, what's wrong with that way of looking at it?
Well, my lord, what's wrong with it is this, my lord. It's not fair to litigants in a system of justice to say that, look, when a judge gives a judgment, let's assume there's no appeal in the matter. It could not, with respect, be the law that where there's no appeal, that when a judge gives a judgment that a litigant is not entitled, as part of the constitutional right of fair hearing, that you get a reasoned judgment. That is what the English Court of Appeal decided in Emery and Remy Bold, that the reasons are an integral part of the judgment.
Unless there's an obvious explanation for what,
sorry, my lord?
Unless there's an obvious explanation for what the judge has done.
Well,
and here, from her comments during judgment, there clearly was.
Well, my lord, that doesn't relieve the judge of the judicial responsibility to make known that fact to the litigant.
It's quite well established, isn't it, that your general principle that every time a judge does something there must be reasons gives way in a cost context to a costs order, which is the obvious consequence of what the judge has just decided.
Well, my Lord,
The judge can just say with costs.
well, my Lord, you see, the obvious consequence, we say, is the general prescribed cost regime. That's the obvious consequence, unless the defendant made an application for budgeted costs or to prescribe a higher value, or even for the judge to step out of that zone to award costs on an indemnity basis, perhaps. But the point is, the general rule that you fall back on is the prescribed costs. And to the extent that you intend to step out of that, my Lord, we say that, look, you know, you should give a reasoned judgment for doing so.
Well, one of the points the Court of Appeal made was that you could have gone back to the judge and asked the judge for reasons if that was a matter that concerned you.
Well, my Lord, we did. That's when I said we did, my Lord. I mean, when we filed a notice of appeal and we indicated that we are appealing both aspects of the order, and that notice of appeal is sent by the Court of Appeal to the judge, the established practice and procedure is the judge will write a judgment to meet that appeal in terms of what.
Well, the appeal said not sufficient evidence for the findings of fact. It said nothing about you haven't given reasons for the costs order, or even that the costs order is one that we object to.
But no, that's true. But bear in mind, we would not have known because we didn't have the transcript at the time.
Well, you didn't need a transcript. There was a counsel for your clients present.
Well,
you didn't have to wait 4 years to identify the fact that you wanted to challenge the costs order, or that you thought that reasons hadn't been given.
Well, can I just take you briefly to page 34?
Yeah. 34?
Yes.
Of the main bundle?
Yes. To show you what was the view of the judges who looked at this in the courts below. In the Court of Appeal, at page 34, line 24, Presiding Judge, Justice of Appeal Barrow, line 24. It's quite obvious. We know that the order for costs does not seem right.
But they didn't have the oral transcript, did they?
No, they did not. No, they did not. But when he says that, my Lord, what he means is that in accordance with the established principles and the jurisprudence that we've got.
Isn't that because she used the word quantified?
Well, no, my Lord. I don't know. I don't think so. I mean,
How do we understand what Justice of Appeal Barrow is talking about?
well, the easier way to understand that would be if I take you to page 90, perhaps. This is the decision on conditional leave to come to the board. And it's a strong panel, and this is the judgment of Justice of Appeal Mendonça, page 90. And this is what he says. We'll grant the application, conditional leave. Basically, the arguments presented were that there are disputable issues, and the Court of Appeal may have erred in making the order that it did. Now, that in itself is a ground captured by 1092A. 1092A is leave to appeal as of right to the board. There is, however, the otherwise ground. That otherwise ground is, or you may grant leave to appeal to the board in such cases as may be otherwise than prescribed. And that otherwise ground, which is applicable where the court may entertain some doubt as to the correctness of the decision, there are issues regarding whether this was an abuse of process, given the proximity of the date of the availability of the notes of evidence to the court of the hearing, to the date of the hearing, the fact that the order made by the High Court judge is not an order that is available to her, in that this is not one of those cases where you may order assess costs. It would either be prescribed costs on a claim treated as $50,000 or prescribed costs on a claim of a value determined by the court. And the parties agreed that what the order says really is really to be treated as assessed costs. So there is that issue.
Well, I thought you just accepted that is not correct, and that it was open to the judge to make such an order. And your complaint was that she didn't give reasons for it.
No, my Lord, no. Permit me to clarify. What I said in response to that is that our primary position is that it's not open to the judge to make that order, because the general position is if you don't make an application for a cost budget, if you don't make an application for the court to prescribe and set a higher value, your fallback position under the rules is the prescribed cost regime.
So you say the judge had no jurisdiction to make the order?
I say in the circumstances of this case, no. I say that, and if she did, I say outside of that, to the extent that she did, and she wanted to depart from the general order, I don't say she doesn't have the jurisdiction of the order, I beg your pardon, no, sorry. But she does. I mean, costs, I think costs are in the discretion of the court.
Yeah.
However, that discretion must be exercised judicially and based on and in accordance with the rules. That is what I say. And to the extent that it has to be exercised in accordance with the rules, we say that the principles that would have applied here is as said here, it would have been the prescribed cost regime, because the defendant never made an application for a cost budget or for any other form to allow the court to step outside of the crease. And if the court intends to exercise that residual discretion, that is a matter that really requires, as I said, an opportunity to be heard and solid reasons by the court.
Well, I would come back to the point made by my Lord Hamlin, that where you've got something so obvious that this is going to be assessed costs, almost certainly on an indemnity basis, but whether that's so or not, your side knows exactly what they're doing. There's no need for reasons to be given. It's blatantly obvious that what she's saying is these costs are going to be assessed. We're outside the normal rule, as you've described it, for prescribed costs, and that's what it is. What's wrong with that? You knew perfectly well the position that you were in. You've been found out. You've come to court, and you've been found to be shameless liars. And then you're now saying, oh, well, we should have had prescribed costs. Surely at the time it was blatantly obvious that the judge was acting outside the general rule because of the circumstances in which you all knew she'd found you to be in.
Well, my Lord, I mean, to the extent that I saw the transcript after the Court of Appeal hearing, that's one way to interpret it. I mean, the discussion that came after that was in the context of the reference to the DPP, and it's not, one interpretation of it is that it came in that context and it wasn't really necessarily part of the court's judgment which preceded it.
But your case was that the documents were forged.
Yes.
The witnesses came to court to that effect. It was then found by the judge that that was a pack of lies.
Yes.
Because as it happened, copies had been kept by the secretary that showed that, in fact, the signatures had been made. You didn't need the judge to tell you you were shameless liars. It was blatantly obvious. She actually went on to say, and there's shameless lying, so much so that I may have to refer this to the DPP. But to then say, oh, well, the cost should have been on a prescribed basis because that's the general rule, in those circumstances, don't you think that's a bit far-fetched?
Well, my Lord, not necessarily, my Lord, for the reason that if the judge had to administer the rules as they are given the way they're structured, the fallback position was the prescribed cost regime, and if she intended to depart from that, I think the correct thing to do would be to give an indication of that to the parties, give them an opportunity, invite them and give them an opportunity to address the court so that they can be given an opportunity to be heard, and thereafter give a properly reasoned judgment.
If that was your complaint, it could have been in the notice of appeal when it was filed, couldn't it?
Well, my Lord,
there's no reason why it couldn't have been. You didn't have to wait for any transcript or anything for that. Counsel who was there knew what had happened at the hearing, and if it was thought that the judge had failed to give reasons or that counsel didn't have a proper chance to put the argument, that could have been raised at the outset.
Well, my Lord, it could have, yes. It could have. It could have.
But in any event, what is there to say? I mean, my Lord Burrows has summarised the nature of the judge's findings against your clients. Why is an assessed costs order not an entirely appropriate order in the context of this case? Where is the injustice?
Well, my Lord, the injustice we say, my Lord, is that to the extent that the learning established in our courts is that if a litigant does not exercise those options to take the litigation outside of the prescribed cost regime.
That's a formality.
You fall back on it.
You've just shown us that it's appropriate for the Court of Appeal to make such order as it considers just in all the circumstances. Well, looking at the circumstances as described to you and summarised to you by Lord Burrows, which I understand broadly you agree with, what conceivably is wrong with the judge's order interpreted as you say it should be interpreted in the circumstance of this case? Where is the injustice in that?
Well, my Lord, can I...
You say it's a formality that no particular application was made.
Well, my Lord, can
If it wasn't obvious, wouldn't the outcome of that application have been perfectly clear?
Well, my Lord, can I answer that by taking you to at least 3 cases from our Court of Appeal, my Lord. The first would be at 753. And this is the case of Kong.
Sorry,
And I take you to page 752.
Where is the start of the case, or just find out?
1 second, Lord.
I think we've got a...
Page 694.
694.
Yes. Now,
Sorry, just give us 1 moment.
694, and I'm taking you to 752. This was a complex medical negligence case that resulted in the death of a mother of 3 children. There were several expert witnesses, lasted several days, and this is what...
I think we had the appeal to the Privy Council here from this case a few months ago.
Oh, that's what I was aware of that, sorry. And at paragraph 99, they dealt with the issue of costs. Well, maybe I'm in time to help someone else, but here we are at paragraph 99. I turn to the respondent's counter notice on costs. The respondent challenged the judge's order that the appellant pay the respondent's costs on a prescribed scale. Mr. Marcus, senior counsel, submitted that the judge should have ordered that the costs be assessed. Alternatively, he should have invoked Part 67.12.3 and carried out the assessment himself at the hearing. He submitted that an order for assessed costs permits the party in whose favor the order for costs has been made to file a bill showing the sum claimed and how it has been calculated. He further submitted this would allow for relevant matters, such as the length of the trial and the complexity, to be taken into account. Now, my Lord, that's a perfectly solid submission that the cost should meet the justice of the case. It was a complex case. Paragraph 101, the respondent accepts that fixed costs under 6-7-4 and budgeted costs do not apply. This leaves to be considered prescribed costs and assessed costs. 67.5 gives the prescribed costs. And then we come to paragraph 105. In 105 it says, in this case, the claim was founded in negligence. It is not an application for an administrative order, so Rule 67.12 does not apply. Since fixed costs also do not apply and no application for budgeted costs was made, the costs fell to be prescribed pursuant to Rule 67.5. The judge was therefore right to order costs to be on the prescribed scale. The parties in this case agreed that there be an assessment of damages, and when the quantum is assessed, the cost will be finalized. That's when you... So, sometimes you'll have a trial, a complex trial on liability. When that trial is completed, you then have a complex trial on the assessment of damages. And what you get, your costs are then calculated on the prescribed basis at the end of that second trial on the assessment of damages. And at 106, the judge says, Mr. Marcus submitted an assessment on the 670 allows for the relevant matters such as the length of trial and complexity to be taken into account. In my judgment, if those were concerns of counsel, then he should have made an application for budgeted costs under Part 67.8. So so my Lord, I understand where the board's thinking is, but what I will say is at least there's an opportunity here to review how we've been approaching and administering these rules, because the general consensus is the cost is to an extent litigant driven. And if the litigant doesn't make these applications to take the judge out, to use a cricketing analogy, to draw the judge out of his batting crease, as it were, then the fallback position is prescribed costs.
But I think my Lord Kitchen's point that even if the appeal had been allowed in the Court of Appeal, or was allowed by us, the order substituted would be the one that was made.
Well, look, and that's fine. If that is the board's decision, then so be it. And its reasoning will help us certainly to say, well, to clarify some of the principles as to how you get to that stage. Can I take you next to page 790, Kumar Mahabir? It starts at.
You accept that an order for assessment of costs can be made?
I do accept that a judge can order assess costs.
You say that should be applied for?
Yes.
You don't have to apply for it by asking for budgeted costs. You can apply for it by asking for assessed costs.
Yes.
Right. Okay.
You can make an application to take it outside of the prescribed cost regime. Yes, you can. And I take.
And that happened in the case you've shown us. I'm not sure it had, did it?
No, and it didn't happen in this case either.
Right.
And the point being made by the Court of Appeal in the case you just cited was that in a medical negligence case for damages, it's too late to come along after the trial when you've won and asked for an assessment. You should ask for budgeted costs, which I assume you've got to ask for at some earlier case management stage, otherwise the budget doesn't make any sense.
Or assess costs, or assess costs.
But at that earlier stage. And what he's saying is counsel should have asked this was a case that might have been suitable for budgeted costs, but not assessed costs.
No, I think the point in the case is you could, if you wanted to take yourself outside of the prescribed cost regime, you had to make an application. You had to exercise one of the options given to you by the rules, namely an application for budgeted costs, an application for the court to fix a higher value of the claim than $50,000, in which case the prescribed cost regime would be applicable based on that. Those are the options, as it were. You can even ask for indemnity costs. You can ask for assessed costs. But if you want to take yourself outside of the general principles, the general rule of the prescribed cost regime, you've got to activate the court by making an appropriate application. And that's the point, my lord, you see? And if that is not done, the fallback position is that notwithstanding the court has a discretion, the fallback position is the discretion has to be exercised in accordance with the rules. And you fall back. So can I take you to Kumar Mahabir, which is another Court of Appeal judgment? I take it starts at page 769. And I'm taking you to page 790 in that judgment. And this is where the Court of Appeal recently detailed the history and the purpose, the policy of it. We turn to the language used to set out the actual cost structure designed for this jurisdiction. The CPR introduced 4 mechanisms or costs regimes of fixed costs, prescribed costs, budgeted costs, and assessed costs, to achieve the aim of making costs predictable, reasonable, and proportionate in different circumstances. They are in fact described as ways in which costs are to be quantified in Rule 67.3. The general rule is where fixed costs do not apply, a party is entitled to the cost of any proceedings, and a party is entitled to the cost of any proceedings. Those costs will be determined on the prescribed basis, that is, prescribed costs or budgeted costs, or when neither is applicable, by assessed costs. See Rule 67.3. Where fixed costs do not apply, prescribed costs are intended to cover all work of the entire proceedings, save that it excludes the making or opposing of any application except at a case management or pretrial review and expert fees, etc. I take you next to paragraph 41 under the heading prescribed costs.
Sorry, I missed that. Which page are you on now? Sorry.
I'm on page 791, my lord.
Thank you.
Paragraph 41, heading prescribed costs. Prescribed costs are the maximum cap of recoverable costs in a proceeding based on a value of the claim approach. The maximum amount of costs recovered by a successful party under the prescribed cost regime is quantified based on the value of the claim and the prescribed formula set out in Appendices B and C. For this scheme, by way of contrast to budgeted costs, the following pertinent observations are made. First, prescribed costs are determined on the value of the claim and the stage at which the proceedings are determined. That is subject to the court's overall discretion to reduce these costs if the circumstances so warrant. Second, the exercise of determining the value of the claim is different for the claimant and defendant. And this is important. It's a bifurcated approach. For the claimant, the value of the claim is determined by the amount ordered to be paid at the end of the trial, or where there's an agreement for value. For the defendant, the value is either determined based on the amount claimed in the claim form, the amount agreed by the parties, or a sum stipulated by the court. This method serves to reduce the prospect of the claimant inflating their claim at the risk of that value being used as a basis to quantify recoverable prescribed costs. Third, if the court must stipulate a value, the court can do so prior to or after trial. The ability of the court to stipulate a value of the claim is different from an application that is made by a party to establish a higher or lower value to recover a higher or lower amount on the prescribed cost scale. Fourth, the obvious rationale of prescribed cost regime is to award a proportionate amount of costs which increases incrementally with the value of the claim. The parties also know, based on this scheme, from the onset of the proceedings, that the recovery of costs is fixed or capped, and that any expenditure above those sums will not be recoverable if they are successful. Fifth, there's a mechanism available to both parties to seek to recover prescribed costs on a higher or lower value. To do this, they may make an application to determine the value of the claim which has no monetary value, which is the case here, where the value is known or where the value is known to direct that the prescribed costs be calculated on the basis of some higher or lower value. Importantly, the mechanism, the applicants consent to any application to increase value and thereby increase the calculable prescribed costs must be evident. More importantly, if the value of the claim is known, there is a threshold test to be satisfied. The court may only make an order if it is satisfied that the costs are calculated in accordance with Rule 67.5 are likely to be excessive or substantially inadequate, taking into account the nature of the circumstances of the particular case, and there is no such express fetter in making an application for budgeted costs. With this regime, once the parties know what is the value of the claim, there is a general idea by both parties of the recoverable costs in litigation. This theoretically ought to translate into proper case management by litigants and attorneys and controlling the expenditure in litigation, which comports with the social aim of reducing costs and access to justice. So,
I've been reading forward while listening to Mr. Ramlal, but I can't see where the Court of Appeal gets to deal with assessed costs. And there's a great long section on the pros and cons between prescribed costs and budgeted costs.
We have her hand up.
Yes. Ms. Haynes-Suhan, you've got your hand up.
My lords, if I may just ask my learned senior counsel to also read paragraph 65 of that decision.
65?
Yes.
Thank you. So I'll ask to draw our attention to paragraph 65.
Sure.
But I'll come back to my question in due course. This seems to have been an appeal about prescribed versus budgeted costs.
Yes. That is correct, my lord. But it's relevant for this purpose in my respectful submission, my lord. It gives you the underlying policy objective, which is to have predictability and consistency and certainty in the application of the cost regimes. That's the first point. The second point is that it establishes, given the structure of the rules, it establishes why, if the options that are open to a litigant to draw the judge outside of his crease are not exercised, there is a strong presumption that the general rule, that he will be bound by the general rule in terms of the prescribed cost regime. My Lord, can I take you to the case next at page 816?
Can I take it in answer to my question that there really isn't anything in this judgment about when it's appropriate to exercise the discretion to order assessed costs?
Well, my Lord,
beyond what you've shown us.
I agreed, my Lord. But you know, the idea is when one makes an application, if one makes an application for that, the grounds of the application would have to be decided on a case-by-case basis, as it were. But, my Lord, can I say this as well, my Lord? What the approach we have taken is assessed costs, my Lord, is only done in Trinidad for claims for administrative orders under Part 56. That is claims for judicial review and the claims for constitutional cases. And there's a judgment of the Court of Appeal explaining why that is so. But assessed costs is reserved for those two forms of cases pursuant to a judgment of the Court of Appeal. Outside of that, and the case is Nizam Mohammed and the Attorney General. I can send a copy to the board. My learned friends will be well familiar with it. But the point is, outside of Part 56, applications for administrative orders, this is the fallback position. Now, can I...
Sorry, are you suggesting now, contrary to what you've been submitting, that the judge didn't, that there's a practice that the judge will never make an order for assessed costs in a claim of this kind? I thought you'd accepted that it's open to the judge to do so in her decision.
How I put it is this. I don't seek to resile from my previous submission. What I submitted is that there is no argument that the court has a jurisdiction to exercise on the issue of costs. However, the jurisdiction that it exercises on the issue of costs must be exercised in accordance, based on and in accordance with the rules. And that is how I put it, my Lord. So, and what I say is that when one applies the rules, it simply doesn't yield the result given in this case. Given the intention of the rules and the way the rules are structured and the way they've been interpreted and applied in our jurisdiction. In that, to draw the judge out of the crease, one of those options would have had to be exercised by the defendant. Well, can I take you to another Court of Appeal judgment at page 815? 815, it's the case of Mary Gomez. And it starts a paragraph, and it's a short judgment. And this is a case, now bear in mind as well, in every case, the judge has to make a determination as to which side you believe. And the side that you don't believe is obviously, whether one chooses to call them a shameless liar, a liar, or you didn't believe them. At the end of the day, one is not meant to exaggerate and put too much on that. In any case, a judge has to decide which side to believe and reject the other side's evidence.
What's the principle you say this case establishes?
It establishes that if you didn't exercise one of those options, you fall back on prescribed costs.
Right. Thank you.
So at paragraph 1, in the court below, they sought a declaration as to their entitlements as equitable owners of 3 parcels of land. And in the alternative, they claimed compensation in lieu of the equitable relief for was not one for a quantified sum of money, which is the case here. The claim was not one for a quantified sum of money. It was a different kind of case. Paragraph 2. The judge dismissed their claims, stipulated a value of those claims based on the valuation of their houses, and ordered that costs be paid by them on the basis of those values. This is what the Court of Appeal said. Conclusion. The appellants haven't been successful on appeal. The order of the trial court will be reversed in any event. However, the order of the court below on costs was not made on the correct basis. In determining the proper basis for an award of costs, both on appeal and the court below, we have the view that stipulation of the value of the claim should not have occurred at the conclusion of the trial, and in any event, they should not have been based on the value of the claimant's houses. Costs in this matter should have been based on the reliefs in the claimant that the claimants actually sought. We are of the view that it would be appropriate to exercise our discretion to take into account that the claim is of an indeterminate value, which could be considered a claim not for a monetary sum, and hence should be calculated at $14,000. That's the prescribed cost regime, and they awarded 2/3 of that sum for the High Court. At page 819, They deal with stipulating the value of the claim, and they say to assign a value of the claim at the end of trial rather than case management was not consistent with the language of the CPR. And then the reason they give lower down at the end of just above letter D on page 820 is this: the unpleasant surprise of extraordinary, unexpected, and excessive cost exposure based upon a value of a claim stipulated by a trial judge at the conclusion of trial often may not be consistent with the overriding objective to deal with cases justly or consistently with the structure of Part 67 itself. So, my lord, the short point is, the object of the rules is not to take litigants by surprise. And that's why, you have to make one of those applications, or litigants are entitled to know and operate on the basis that, look, it is the prescribed costs which will define my risk exposure in this matter. And that is the consistent jurisprudence that we have culled based on these rules and applied in Trinidad since they've come into existence.
But you accept that it's open to a judge, if a claim is found to be a fraudulent claim, to make an order for assessment of costs on an indemnity basis?
Well, I can't say that a court doesn't have that jurisdiction. I can't make such a submission.
Right.
But what I do say is that the rules does not appear to have catered for that in the rules. And if a judge intends to make such an order, it would be a draconian order out with the rules that a judge would have to put to the parties expressly, give them an opportunity to be heard, and give a properly reasoned decision, not by deduction and inference, as we are seeking to do here, not by reasonable or unreasonable speculation, deduction and inference, but a properly reasoned judgment after putting that to the parties and seeking and giving them an opportunity to be heard. So that I can't say that the discretion, the jurisdiction would not exist, but it is going to be a very exceptional one, and can only be exercised in that manner that I've outlined, my lord. For it to be a just and fair order, because it runs contrary to the entire policy objective of the rules, which is to let for predictability, consistency, and certainty.
May I ask this? I mean, you've made that submission now, I think, twice. How is a defendant supposed to protect itself against a fraudulent claimant? Where is the certainty or predictability about the nature of a claim of that kind?
Well, you can make an application for a cost budget, or to set a higher value for the claim, and in your grounds in the application, you can say,
anticipating that the claimant may be found to be fraudulent.
No, it's not a matter of anticipation. If your defense is that this is a fraudulent claim and it's hopeless and it's unmeritorious, you too ought to know up front that your case is that this is a fraudulent claim against me, and you put that in the grounds. We've done it. So you put that, and you red flag for the opposite party. That's the point. By doing that, you red flag for the other side and the judge up front. So they know if they continue with that litigation, in light of that, they do so at their own peril, with a risk exposure to costs that is out with the normal prescribed cost regime. And that's the point. You've got to make that application.
But what is the application for?
The application for...
You're talking about making the application before trial, at some case management hearing, as I understand it.
Yes.
So what does the judge order on such an application? Does he just say, well, I've heard the red flag, and you, the claimants, need to bear that in mind, and let's now carry on?
No. What the judge will do, the judge will fix a cost budget.
But why does a budget answer an application that this is a fraudulent claim?
Well, because the judge, my lord, can fix a cost budget.
But that's only one of the four mechanisms, and you're contemplating that the defendant might say, well, I contend that this claim is fraudulent, and if that's the conclusion at trial, I should have the costs assessed.
Yes, you
And as
can-
my lord says, the judge can't decide that until the trial's taken place, whether that's appropriate.
What normally happens, my lord, is in the application you can plead the relief in the alternative. So you ask for a cost budget in the alternative that they set you say you fix a value of this claim at say 800,000, or so that you'll be outside the prescribed scale, or you can say I ask for the cost to be assessed on an indemnity basis. Whatever you want, you can ask, and you put it in the grounds. Now the judge.
But you can't sensibly ask for costs to be ordered on the indemnity basis at a case management conference in advance of a trial at which the question whether the claimants are being fraudulent is yet to be determined.
Well, my lord, if that's the if that's your case, and you have strong reason to believe that on the basis of your instructions that's the case, you can put it in the grounds, and it's a matter for the judge. A judge, for example, faced with an application, can also, my lord, say, well, look, I'll defer the application until the stage of witness statements, perhaps, as the case may be. So that, I mean, there are many options available for the case management judge as to how they would treat with the issue. Now, my lord,
Will you be coming at some point to address us on why you say either the Court of Appeal or this board has jurisdiction to entertain the argument at all, in the light of the statutory provision you showed us some time ago and the fact that there never was an appeal on costs?
well, my lord, yes, can I do so now, please? Thank you. Can I take you to page 758? It's the case of, an old case of the board, but we say it's still good law. And I'll just take you to the head note where there's symbol. And it says, where there has been a mistake upon some matter of law that governs or affects the costs of the suit, the party prejudiced has a right to have the benefit of its correction by appeal. So that's the guiding principle.
Well, this is a case before the Judicature Act, is it?
Yes, my lord, it is. It is, but I
It's
say
not an authority on the effect of the statutory provision that you showed us.
Well, my lord, I'll come to specific cases, but my submission on this is that principle of law applies under the statutory provisions and guides those statutory provisions. Can I take you next, my lord, to a case of at 833?
So you don't want to go beyond the head note of this case?
No, I don't think I need to, my lord. Can I go to some specific cases?
Yeah.
833.
In answer to my lord. 833. It's the case of Sanguinet. It starts at...
Yeah.
Can you copy? Yeah, it begins at 825. And I'm taking you to 833. And it says, at 833, it says, counsel submitted, and this is in paragraph 19, counsel submitted that the appellant's notice of appeal is null and void for the reason that the appellant did not obtain leave to appeal. Counsel referred to Patrick and Walker, where it was held that the notice of appeal which was filed without leave, having been first obtained, was a nullity. The question is whether leave to appeal was necessary before the notice of appeal was filed, decide section 38.2, and it has been held that this section does not apply in every case where an order as to costs has been appealed from. In Bolai and St. Louis, it was recognized that there was an established rule of practice that where there is a bona fide appeal on the merits or where the judge has fallen into an error on a point of law which governs or affects costs, an appeal will be heard without leave. It has also been held that where it has been shown that the discretion to award costs has not been judicially exercised, in that the judge considered grounds wholly unconnected with the cause of action or has no relevant grounds, leave was not necessary. Lush and Dupree. What has been contended in this appeal, as will appear below, is that the order for interim costs was wrong on points of law. I next take you to the case of Gulview Medical, which I think, my lord, has come before you as well. Starts at page in the supplemental bundle. If I may switch to the supplemental bundle. It starts at page 2. And I want to go to page 5. Are you with me, my lords? It's in the supplemental bundle. It starts at page 2, and I'm on page 5. And this is the same, as you'll see from paragraph 13, it's the same section. It's not a cost order, but it's a final order for judgment in a summary proceeding. And the question again was no leave was granted. And I take you to page 18. Leave to appeal, paragraph 51, page 18. As to the issue of leave to appeal, applying the application test, the order in this appeal is clearly not a final order for the purposes of Supreme Court. The application test, they deal with the question of whether it's a final order or not. But in the end, no leave to appeal is granted, and the relevant part in the end would be, it is therefore not a final proceeding, but they say in any event, like Justice of Appeal Smith, I would have granted the appellant leave to appeal. Now that's Justice of Appeal Barrow, and Justice of Appeal Smith dealt with that. Give me actual hard copy, please. Yeah. And Justice of Appeal Smith had dealt with that above, and he had also likewise said, well, look, even though leave had not been granted, he was prepared to grant leave himself. So that even when no leave was granted, the Court of Appeal was prepared. They do have the jurisdiction and power, and they can and have in fact granted leave themselves. Another case that occurred in recently. What page? As page 6, we will see Justice of Appeal Smith. Page 6, page 7. Page 7. Paragraph 22, this is Justice of Appeal Smith who gave the main judgment. He said, in any event, even if leave were needed by the wording of section 38.2c above, and remember that 38.2 deals with all of the, including costs as well, cost appeals, this court has a concurrent jurisdiction to grant such leave. The main factor to consider in determining the grant of leave is whether the application has a realistic prospect of success. The determination of whether a case has a realistic prospect of success is a preliminary assessment, and that is made before full argument and consideration of the case. Now, what we do say, my lord, is that insofar as this is the test, the Court of Appeal, having implicitly recognized the order was wrong, then they ought to have granted leave and dealt with the matter. I take you next to page 27, CPEP. This is the case of CPEP. It starts at page 24, and I'm taking you to page 27.
So what's the name of the case?
It's CPEP Company Limited versus Dr. Rudal Munilal. I take you to paragraph page 27. Page 34, firstly. Again, it's the same section in section 38.2 of the Supreme Court Adjudicature Act, no leave to appeal, as you'll see in paragraph 15. The appellant failed to apply for leave, and as such, the appeal is a nullity and ought to be dismissed. That was the contention, which is in fact the case here. And the Court of Appeal dealt with this at page 36, paragraph 23. And they say, the second preliminary objection asks the question whether leave under section 38.2c is required. It is clear from that section if the order of the judge to strike out is a final one, leave would have been necessary. It is not disputed that leave was not obtained before the appeal was filed. There are two main issues to be determined, and they were submitted. It was not a final order. And then they go to paragraph 25, where this issue of summary proceeding was discussed in a case before the board in Dugna Raj Kumar. And the paragraph 26, they say this. Further, Nelson J.A. noted that if leave is required and not given by the judge of the High Court, the Court of Appeal may do so. The jurisdiction of the Court of Appeal to grant leave is concurrent with that of the High Court. It is not a condition precedent to the jurisdiction of the Court of Appeal that an application must first be made to the High Court. He stated it would be open to the appellant to seek leave after the filing, or for the Court of Appeal in its inherent jurisdiction to grant such leave. In relation to the case before him, he said that if leave were necessary, he would grant leave and treat the notice of appeal as effective from the date of its filing. And Lord Mackay and Raj Kumar, speaking on behalf of the Privy Council, he did basically making the point that the Privy Council didn't take issue with that approach, as it were. Can I next take you to page 921? Sorry, this will be going back to the main bundle, sorry. Yeah. So if I go to the main bundle, back to the main bundle at 921, this is the case of Shearer and County Instruments. It starts at page 919. At letter H at the bottom of 921. The judge was not asked for and did not give leave to appeal as to costs. And they say under the Supreme Court Conciliation Act 1925, costs are in the discretion of the court. They cite the provision, they say at page 6 below. So if a judge has made an order for costs, having material before him upon which he could exercise his discretion in that way, the court cannot interfere with the decision unless it's brought with leave. This court can, however, interfere if, upon a true view of the facts, the judge has exercised, has either not exercised the discretion at all or has exercised it in otherwise than judicially. What comes to, I think, is that in order to justify an appeal as to costs only, the court must say that the judge in the court below, however much he's been purported to exercise discretion, did not really exercise it, and took into account extraneous relevant matters, or that he didn't exercise it judicially.
But in this case, the judge did have material before him or her upon which she could base an order for assessment of costs, didn't she?
Lord, one can say yes to that. What I do say, my Lord, is these cases, this case, the two cases I cited from the Court of Appeal are current post-CPR cases. The learning from these older cases, one has got to take with a pinch of salt, simply because under the older rules, there might have been a difference where you do a retrospective survey of the legal battlefield and try to deduce and infer whether or not there could have been material that could have the judge could have applied their mind to justify the order made. But here, where the rules are structured so as to provide specific cost options, whereby if a party can make applications to to take themselves outside of the general rule of the prescribed cost regime and does not do so, what the rules provide and what the jurisprudence establishes is that you fall back on the default position of the general prescribed cost regime. And that is how it is set up. So that there is no retrospective surveying of the legal battlefield to deduce and infer by a process of deductive reasoning that, well, had I been the trial judge, I could have justified this order, and I would have made it. It should have been made. So here goes. That's not the correct approach with respect. The correct approach is, as set out by the Court of Appeal, with respect, that if a litigant chooses not to exercise any of those options open to them to take it outside the realm of the general rule of prescribed costs, then that's the fallback position. And if in the outside chance a judge wishes to operate exceptionally beyond that, we say that what should happen, at minimum, the judge has to indicate to the parties that, look, I have in mind that I wish to make an order that is outwit the usual orders and the options available and prescribed in the CPR, and I'd like to, here invite submissions on it. And then, of course, give a properly reasoned judgment on why.
Well, we know that's your argument.
Yeah, well, thank you very much. Sorry. Well, can I take you to back to the supplemental bundle just to show you one thing, which I promised to show you, and it's at part 64.8. What page?
Sorry, what page?
Yeah. What page starts now? 55, I'm told. Starts at 55. I'm looking for 64.8, which is at page 59. We had a copy. Yeah. That's fine. And it's 64.8. It says, upon the notice of appeal being filed, the court office must forthwith B, if it's not a procedural appeal, arrange for the court below to prepare a transcript or other record of the notes of evidence and of the judge's reasons for giving the judgment. And when these are prepared, forthwith give notice to all the parties, copies of the transcript, etc. I show you that because, my Lord, in response to my Lord's inquiry as to whether the parties have been writing, I did mention to you that the practical administration, in terms of how it operates, is once you file the notice of appeal, it is the Court of Appeal that takes the responsibility for getting the transcript and the judge's reasons. Now, my Lord, look, the practice is oftentimes you don't get a judgment.
This isn't a procedure which entitles the judge or expects the judge to give new reasons. As I understand it, it's simply that the office then gets a transcript or record of the notes of evidence and a transcript or record of the judge's reasons for giving the judgment.
But that's correct. But
and as you knew there weren't any, there was no need to wait for the transcript.
Well, my Lord, what sometimes happens is, my Lord, a judge may give a decision. They may give sometimes summary reasons, or they may say, I will give my reasons if necessary in the event there's an appeal. I mean, different things happens. But the short point I'm making is that in this case, there was no fully reasoned judgment. An appeal was filed, and to the extent, what would normally happen is that you would get a fully reasoned judgment thereafter. We got that, and we have that with us, but it didn't address the issue of the costs. And the transcript, we got that, after the hearing of the appeal, and that also, in my respectful view, submission does not, in fact, address the issue of the order for costs either. I understand the board. We can make inferences as the case may be, but is that really what the law required? I mean, you've got my submission on that, my lord.
Can I ask you, while we're on this document on page 58, Rule 64.4.
Page
58 of
yes,
the supplemental bundle, Rule 64.4, paragraph 8. The appellant may not rely on any ground not mentioned in his notice of appeal without the permission of the court.
Yes.
Was the permission of the court obtained or even sought to rely on the ground that you're now seeking to advance?
Well, we say yes in our written submission, but we say in any case, have a look at 9, which says, however, the court is not confined to the grounds set out in the...
Well, the court isn't, but the appellant, which is you, may not rely on any ground.
Yeah.
So if you say that permission was requested, either to rely on the ground not mentioned in the notice of appeal, or to appeal under and therefore get outside section 38, it would be helpful if before you finish you could give the reference to where you say the application was made.
All I can say to that, my lord, is that in the written submissions which were filed, we plainly abandoned the appeal any appeal as against liability and gave immediate notice in our submissions because, my lord, one has to bear in mind how things unfolded and the timeline. We had a deadline to comply with the file of submissions. We were waiting on the transcript from the court. We couldn't get it, so we immediately put in our submissions based on what we saw in the judgment that, look, there's nothing on liability. The only issue that we're taking issue with is the issue of the costs. And we say, my lord, that we ought to have been allowed, and the court, even of its own motion, should have entertained that, my lord. Can I take you quickly, my lord, next to page 892 to a judgment from the Court of Appeal. It's in the main bundle, and it's Trinidad 892. And it starts at page 861, and I'm taking you to paragraph 70 at page 892. And it says, the general rule is where 67.4 does not apply, and a party is entitled to the costs of any proceedings, those costs must be calculated in accordance with the percentages specified in Appendix B against the appropriate value of the claim. Rule 674 provides for fixed costs, which are applicable where the claim is for a specified sum of money.
Well, we know what the general rule is, but the whole issue in this case is to whether it applied or it didn't. So this isn't going to help us, is it?
Sure, my lord. Well, it helps us only to the extent that the court will again reinforces the point I made earlier, that look, if you're stuck with the 50,000 rule if you don't make an application. Can I take you then quickly?
What I think your case comes to, as far as I can see, is that if the claimants wanted costs outside the the prescribed regime, they had to make an application for it. But if your clients wanted to challenge the cost order made by the judge, they didn't have to make any application.
No, I'm not saying the latter.
To amend their notice of appeal and plead it as a ground of appeal, or seek permission.
Forgive me, I'm not saying...
The court ought to have done it of its own motion without your clients even asking for it.
I'm not saying the latter, my lord.
Well, if you're not, then when did your clients ask for it?
Well, my lord, I can't say that... Lord, I can't say that an application was expressly made for the leave. I'll come to it in the transcript as best I can.
Well, the highest it's put, isn't it, is your written submission.
Yes, I accept that.
Is it put any better than that on your? Can it be put any better than that for your side?
I'll take you to the transcript to see as best as I can, my lord. But I think I would have to start with the submission. I agree with that.
Are you going to show us that briefly?
I will, my lord, briefly. Yes. Can I just complete this case's judgment quickly? Page 894. This is what the procedure is. They cite Justice Yamada in Faviana Gajada. Having determined a substantive matter in favor of the appellant, the trial judge decided the issue of costs without hearing the parties on either what was an appropriate order to make or on the assessment of costs payable. In our opinion, the judge's approach to the issue of costs was erroneous. First, having determined the matter in circumstances where neither party addressed the issue of costs, the correct approach to be taken, as is a consistent practice in these courts, was to invite the parties to make submissions on both aspects of costs. One, the appropriate order to make and the reasonable quantum to be awarded. Rule 66 contemplates an exercise of judicial discretion in determining who should pay costs. Further, the factors to be considered and weighed are contextually bound. Further, the factors to be considered and weighed are contextually bound and are capable of producing different outcomes depending on the circumstances of each case. As such, parties should generally be given the opportunity to make representations. Fairness and justice demand no less, and the decision-making process can only benefit from such an approach. It is clear the court had the discretion to vary the costs prescribed by the CPR. However, a move away from these guidelines, the judge must give a reason for doing so. A judge is obliged to give reasons for making an unusual order as to costs, unless, of course, the reasons are deducible from the rest of the judgment. The consequence of the failure to give reasons when reasons are required will often be to require that this court set aside the order for costs and exercise an original discretion as to make the appropriate cost order. Paragraph 77, they go through it and they said that the judge was plainly wrong to provide reasons for the unusual award that was made. That's at 78. So that's the established practice, and that's what we rely on.
That was a case where a specific cost order was made, was it?
Yes, my lord.
So here you've got an order for assessment, so presumably on assessment, you can raise points about the appropriate amount of costs.
Well, the short point is the judge did not apply the prescribed cost regime. They stepped out of what the general position should have been. And the point I'm making is this: if you're going to depart from the general default position, that's the procedure to be followed. That's the established practice and procedure.
Unless the reasons are deducible from the rest of the judgment.
Well, my lord, yes. But one has to connect the reasons. One can't hypothesize about the reasons being there. One has to connect the reasons, the judge has to connect the reasons to the actual order for costs. And that wasn't done, with respect. I don't think that would be the way to look at it. So now, can I take you to the transcript now to the question of
Sorry, which transcript are we going?
the Court of Appeal transcript, and in the main bundle of paragraph, I'm taking page 34.
Page, please.
34.
34.
Yes.
Thank you.
And at page 35, line 31.
Sorry, 35.
Yeah, page 35, sorry, my lord.
Right.
Line 31. Justice Barrow says, all right, now you want to argue, you want us to hear you on the question of cost because the order does, on the face of it, appear to be irregular in relation to prescribed costs. My lord, I've set it out, and then Justice Guru Singh makes an inquiry. And there's, after that long passage, there is at page 41, at page 41, line 29, Justice Barrow, well, he should be entitled to pursue his appeal here. Yes, please, my lord. And that is insofar as it's not contained in the grounds, you can apply under 64.9, and that's 64.9b, to which we just had reference. And yes, my lord. And Justice Barrow says, all right, but this is predicated upon your appeal being a genuine appeal. My lord, I think that's as far as I can take it in answer to my Lord Legate's question on the question of whether there was an express application for leave. All I can say is in the course of the discussion in the hearing of the Court of Appeal, it was, it's clear that the counsel was, in fact, asking, as it were, for leave to appeal, but his primary position, to be fair, was that leave was not required, because when the notice of appeal was filed, it was a notice of appeal that dealt with both liability and damages. And insofar as parties often do that, because you have to file a bare notice of appeal if you don't have the judgment, and you will abandon grounds, as the case may be, when you get things as things progress.
Well, it wasn't just his primary argument, it was his only argument, wasn't it?
Well,
because what you've shown us is that if he got to it being a genuine appeal, then he would have asked to amend the grounds. And so you've addressed the paragraph 69.9 point. But the only argument being made as to why the Court of Appeal could entertain the appeal at all was because there was a genuine appeal on other grounds, even though they weren't being pursued.
Well, yes, that's fair. I can see that. But what I will say in closing on that point, is this: the genuineness of the appeal, given the fact that the judgment was not yet available, I asked the court simply to bear in mind what the reality of the situation is. Judges sometimes give an oral judgment. Sometimes they may not give full reasons. Sometimes the judge may just give you an email of what the decision is. And oftentimes, because you have to comply with the deadline, you would file the bare notice of appeal. And when you get the judgment, then you act accordingly. You may abandon grounds, as the case may be. So that oftentimes it happens. You will file a notice of appeal challenging the liability and the costs.
Can I see if this is a fair way of looking at it?
Sure.
There may, in the circumstances that you haven't yet got a transcript of an oral judgment or the judge's reasons or the notes of the evidence, be a genuine desire to mount an appeal. And you may seek to, as it were, put a marker down of that genuine desire by putting in effectively a dummy notice of appeal with no grounds and no specification of why you're appealing. But once you have got those materials, the question whether it gets from being someone who genuinely desires to appeal to someone who is genuinely appealing depends upon whether at that stage you put in a properly formulated notice of appeal with proper grounds in it.
Well, I can accept that.
Thank you.
Yeah, I can accept that.
But it may lead to the consequence that in this case, once your side had those materials, that wasn't done, so that it never moved from being a case in which there was a genuine desire to appeal, if possible, to being one where there was a genuine genuine appeal about anything other than costs.
But not with the only qualification that the transcript was still being awaited, and bear in mind that the judgment which was received simply did not address the question of the reasons for the cost decision.
That I understand.
Yes.
But
But I accept that,
notion
yes.
to get a costs appeal, which is a cost-only appeal,
Yes.
off the ground, it must be twinned with a genuine appeal, means that the genuine appeal has to be about something else.
I accept that, my lord. Ab initio, or I would say ab initio, my lord.
Yes.
Not necessarily. I don't accept, my lord, that you can't abandon, the liability.
I understand your point. If you get a genuine appeal about something else
Yes,
off the ground,
of course.
with a properly formulated notice and grounds, you can still abandon it
Yes.
without your costs appeal having been tacked to a genuine appeal.
Yes, and the short point is...
Your problem is you never put in
No, I accept that.
notice of
I
appeal
accept
or
that.
grounds about anything other than
Yeah.
costs.
Well, what I'm saying is that in those circumstances, when you abandon, you don't need leave
No.
to maintain the cost appeal.
No.
That's as far as I can. That's as far as I can take it, my lord.
Thank you. Well, now, the clock is slightly slow, according to my
Is it?
computer. But if there's anything you want in another minute, Mr. Ramlal.
My lord, all I can say in a minute is this, my lord. I think our jurisprudence would benefit immensely from the board's judgment in this matter, insofar as the ability and circumstances and principles which would apply when a judge can step outside of the prescribed cost regime, and how that is to be done, and what's the procedure to be followed.
Yes, thank you.
Is that something that's really appropriate for the board to be grappling with, unless it's absolutely necessary, given that we don't have the same understanding that the Court of Appeal does of the background to these cost rules and the conditions in Trinidad and Tobago?
I say yes because ultimately what the board will have to do is to say that, look, the departure from the general rule in this case was justified by reference to obiter dicta comments the judge made post the delivery of her actual judgment, which we say dealt with a specific issue that might have been unrelated to the judgment itself or related, which dealt with a reference to the DPP. And if the board is going to approve that departure from the general fallback default provision on the prescribed cost regime, then yes, it would need to be, it would be an opportunity to properly explain why and when that is permissible.
Thank you.
Deeply obliged.
Thank you very much. Ms. Jesus, on, give us 1 minute.
Sure.
I think we should have
Ms. Jesus, we're just going to retire briefly, probably not more than 5 minutes, to consider where we've got to so far. So if you'd be kind enough just to wait for that before we come back to you.
Yes, please, my lord.
Yes, Ms. Jesus, please proceed.
Good afternoon, my lords. Good morning to those in Trinidad. My lords, it's clear from the authorities that that leave is not required where there is either a bona fide appeal on the merits or where the judge has fallen into error on a point of law. I appreciate that I only have a few minutes before the lunch break, but I do wish to make the point that at the time of filing the notice of appeal, the appellants were fully aware that the court had ordered assessed cost, and therefore, under their grounds of appeal, one of the grounds should have been that the court erred in law in awarding assessed cost. but they failed to include any ground at all, although it was known at the time of filing the notice of appeal that the judge had made an order for assessed cost. And my lords, I will quickly take you to the Scherer case that my learned senior just left. It's tab 15, page 919 of the bundle of authorities. And I wish to take you to page 922. My learned senior stopped right above the relevant paragraph at E, please, my lords. So where, in considering whether I start at D, in considering whether the judge had any relevant material on which he could base his exercise of discretion, we must first decide in relation to what proceedings and consequently what issues he had to do so. So our first submission is that these proceedings are one based in fraud, and we have made our submission on the appropriate order for cost to be made in fraud matters, please, my lord. And with regard to the issues, he had to do so. And if we go down to right above E, it says where there's a trial of the matter. In such cases, no doubt, the relevant field to be scanned is the whole battlefield of the action and the whole conduct of the parties in relation to the matter in dispute may be relevant. So we say, my lords, in determining whether the judge exercised her discretion judicially, you look at the entire battlefield and you look at the conduct of the parties in relation to the matter in dispute. And my lords, before the lunch break, I just wish to take you quickly, very quickly, to the evidence in this matter, because, my lords, the appellants maintain, as I understand it, that their appeal was a genuine one. Please, my lords. So that would be the first issue that we need to look at. And my lords, if I can first take you to the witness statement of the first appellant, which can be found, one moment, please, my lord, which can be found at page 373, the witness statement of Phyliss Rampersad. And my lords, you would be aware that in this matter, both the appellants alleged that they never signed the deed in question, they never went to the attorney's office, and their signatures were forged on the document. And my lords, if I can take you to page 381, paragraph 35, the first appellant in her evidence, and these documents would have been in the possession of the appellants and their attorneys at the time of filing the notice of appeal. At paragraph 35, the first appellant says, I'm a geriatric nurse and I do home visits. During the period November 2004 to March 2009, I was employed by Phyliss Rampersad of Kelly Village, Caroni Village, attending on his mother, Molly Rampersad, who had suffered a stroke and was bedridden. I worked on weekdays from the hour of 8 a.m. to 4 p.m., sometimes 5 p.m. Sometimes I worked on weekends and I would stay late at nights if Suresh and his wife needed to go out. I was paid weekly by the Rampersad family. I did not take any time off to visit the attorneys for the first, second, and third defendants to execute any deed on the 24th of March 2005. So that is the first appellant's evidence, right? She never signed, she never went to any attorney's office. If I can quickly take you to the evidence of the second appellant, which can be found at page 179. And I'm taking you, my lords, to paragraph 3, which is on page 180. The second appellant says, my wife and I attend the Mount Zion Spiritual Baptist Church, Carmichael Village, Tamana. From the 24th to the 27th of March 2005, I was mourning at the said church and could not leave the church's compound until the 27th of March 2005 after Sunday morning service. The process of mourning involves me being locked in a dark room with my eyes covered for the entire period. I spent 3 days mourning, beginning on the Thursday the 24th and ending on the 26th. However, on Wednesday, 23rd of March, I went to the church to prepare myself for mourning, and I remained at the church in Tamana until the end of Sunday morning service. And so the second appellant says, well, I was in church, I was mourning. And if you look at paragraph 2, his witness statement is only 3 paragraphs. If you look at paragraph 2, he says, I say that my wife and I never on the 24th of March or at all attended the offices of Mona Nahus Alwari, attorney at law, or at any other office, and we never signed the deed number so-and-so, the relevant deed in these proceedings. And my lord, if I can quickly, my lords, take you now, right before the lunch break, to the witness statement of Mrs. Mona Nahus Alwari, which can be found at page 293. And the first paragraph, my lords, I will take you to is paragraph 8. Mrs. Alwari says at paragraph 8 that at my office, that the appellants came to her office. I requested identification cards of both the vendors and the purchasers. The appellants were the vendors, which they provided and which I examined. I instructed Mrs. Das, who is her secretary, to make copies of these ID cards and keep them on files. And keep copies in the file for my records. And she attaches the ID cards of the appellants as an exhibit. And you would see in the judge's reasons, which was available quite some years now, that the judge said that the appellants could not give a satisfactory reason. They could not give a reason at all how Mrs. Nahus Alwari had copies of the ID card if they never visited her office. And my lords, quickly again, I take you to paragraph 11 of Mrs. Alwari's witness statement. And at paragraph 11, Mrs. Alwari annexes to her exhibits to her witness statement 2 checks that were paid to the appellants on the day that the deed was executed. And we are all aware that in conveyancing, you sign your deed and you exchange the check for the balance of the purchase price because a deposit was already paid. And if you look at exhibit 7, which is on page 3, it starts 325, please, my lords. You would see on page 326 that there is a stamp where the appellant actually deposited the check on the same day that the deed was executed, the 24th of March, and that he actually signed at the back of the checks when he deposited the checks. And this again was something that weighed heavily in the judge's mind, and she included in her decision both the oral and the written. She said the first appellant acknowledged that was her husband's signature on the checks. And the check stamp was deposited on the same day that the deed was executed. The same day, the appellants say, I was working as a geriatric nurse and I was mourning in a church. And so, my lords, I will stop at this point in terms of whether this appeal was genuine in the first place. And I will continue my arguments if the board wishes, after the lunch break.
Thank you very much indeed. We'll resume at 2 o'clock.